NDI Checkpoint web conference series. Today's conference is being recorded. At this time, I'll turn the conference over to Ms. Jennifer Bartz. Please go ahead, ma'am.
Thank you, James. I would like to welcome everybody to our fourth session of our 2013 National Directors Institute web conference series. We are in our 12th annual NDI season, a program which we started in 2002. As with our NDI programs in years past, we're looking forward to sharing the insights and experiences on corporate governance issues that we think matter most to you. The goals and objectives of our NDI program have always been to provide practical insights and useful takeaways to directors, executives, and boardroom advisors. Materials for our previous NDI webinars and other sessions, including PowerPoint presentations and audio recordings, are available on our dedicated NDI website, which is foley.com/NDI. Information regarding future NDI webinar sessions will be found at our NDI website as well. We held our in-person 2012 NDI Executive Exchange in Chicago on November 14th. Please go to our NDI website to find many valuable program materials from that all-day program. Our next invitation-only in-person NDI Executive Exchange will be held Wednesday, November 13th, 2013. Be on the lookout for information. And for the first time, Foley invites you to submit a nomination for our Director of the Year Award program. Awards will be given to a private and a public company director and will be announced during the NDI Executive Exchange. To obtain a nomination form, visit foley.com/NDI. I'd like to take the opportunity to thank all of our NDI co-sponsors, many of whom have been supportive to NDI for years, and some who are new to our program this year. Aon Corporation, V.F. King & Company, Eversheds LLP, KPMG, and Morgan Stanley, as well as our in-kind sponsors, Boardroom Bound and Inforum Board Access. Today, our program is entitled Director Duties in the Zone of Insolvency. With us today is Judy O'Neill. Judy is a partner in Foley's Detroit office and former vice chair of Foley's National Bankruptcy Group. Ms. O'Neill practices in bankruptcy, insolvency, reorganization, commercial transactions, and corporate law, and has handled bankruptcy and restructuring transactions for companies in varying industries ranging from $100 million to $2 billion in sales. Also with us today is David DeRita. David is of counsel in Foley's Detroit office and is also co-founder of the Roxbury Group. Previously, Mr. DeRita served as Senior Vice President, General Counsel, and Secretary to Power Automotive. In this capacity, he was charged with overseeing the company's successful emergence from Chapter 11 bankruptcy. Mr. DeRita has also held positions at Visteon, the Automotive Systems Group of Johnson Controls, Alexander Hamilton Life Insurance, and Dickinson Wright P. LLC. Additionally, we have Stacy Fox. She is of counsel in Foley's Detroit office and is also co-founder of Roxbury Group. Stacy has 30 years experience as a corporate and restructuring attorney and executive advisor to CEOs and boards of directors. Ms. Fox has held positions at Sunoco, Collins & Aikman, Visteon, Johnson Controls, and Unisys Financial Corporation, and the Mintz-Levin Law Firm in Boston. While at Collins & Aikman, Stacy was asked to join the restructuring team where she was responsible, together with the company's outside advisors, for developing and executing the company's original Chapter 11 reorganization strategy and later its liquidation and wind down, including supporting negotiations with the company's secured and unsecured creditors and prospective equity investors, restructuring of UAW pension and OPEB obligations, negotiating favorable settlements and Securities and Exchange Commission and Department of Justice with respect to ongoing 34 Act reporting obligations and past accounting violations, and helping reorganize other material liabilities to the satisfaction of the secured creditors. Tom Bibby is the Southwest partner in charge of KPMG's restructuring practice and is based in the Dallas office. Tom has nearly 25 years of experience serving as a financial advisor to debtors, creditors, and Chapter 11 trustees. Most recently, Tom served as the financial advisor to the Dallas Stars Hockey Club and Pension Worldwide. In addition, he assists buyers and lenders with acquisitions, due diligence, including performing strategic management and financial assessments, and providing out-of-court restructuring assistance. Finally, we have Chris Lee from Morgan Stanley. Chris is a managing director in Morgan Stanley's Mergers and Acquisitions Group, where he leads the Special Situations Advisory practice. Chris has spent 13 years working in distressed advisory, including working both at Lazard and Rothschild's restructuring advisory practices prior to joining Morgan Stanley in 2008. Chris's work to date has primarily been advising debtors as well as independent committees, as well as buyers and sellers of distressed companies. Notable transactions he has worked on include Dex Supermedia merger, dual prepackaged bankruptcies, Crown Media's out-of-court recapitalization, Archstone's sale to Equity Residential, and GM's 363 sale to the U.S. and Canadian governments. Before beginning our discussion, a few housekeeping items. Today's program will last approximately 1 hour. The PowerPoint presentation will be available on our website at foley.com/NDI by early next week, or simply click download a copy of the presentation in the Files box along the right side of your screen. If you experience problems with Adobe Connect, please call 888-569-3848 for technology assistance. For audio assistance, dial star, then 0 on your telephone to reach an operator. Today's program has been set up in both a discussion and an interactive question and answer format. We encourage you to submit written questions during this program. Type your question into the Q&A box at the right side of the presentation slides. We will respond to written questions at the end of the program, time permitting. If we do not have time for Q&A at the end of the program, we will be sure to follow up with you offline. To ensure you get the most out of today's presentation, we encourage all participants to maximize the PowerPoint to full screen usage. You can do so by clicking the full screen button located above the slides. As a reminder, today's program is being recorded and will be available on Foley's website by early next week. Foley will apply for CLE credit after the web conference. If you did not supply your CLE information upon registration, please send an email to Jennifer Bartz at jbartz@foley.com. Please note, those seeking Kansas, New York, and/or New Jersey CLE credit are required to complete the attorney affirmation form. A 4-digit code will be announced during the presentation. Email the code to jbartz@foley.com to get a copy of the form, or simply click the download form to download the form from the Files box along the right side of your screen to get a copy right now. Immediately fill it out and return it after the program. Also note that you must log on to both audio and video to obtain CLE credit. Finally, it can take 6 to 8 weeks for us to obtain all CLE approvals. We appreciate your patience at this time. And now, I will turn the microphone over to Judy O'Neill from Foley and Lardner.
Welcome. When I'm asked to represent a company that's in trouble, one of the very first questions that I get asked is, what are our duties and obligations as board members and as officers? So we start today by going over those basics. First, what are the fiduciary duties that a director owes to the corporation, and to whom are they owed? The duties, there are 2 duties. They're the duties of care and the duty of loyalty, and they are owed to the corporation. While the dynamics are often different between a public and private corporation, because obviously in a privately held corporation, your ownership is often at the table, a little more distilled than a public corporation, those duties remain the same. And in many instances, for the new kinds of forms of entities like LLCs, similar kinds of duties are owed. So we need to start today by going through those basic duties to explain to you what they mean in the context of an insolvent or troubled company. First is the duty of care. The duty of care governs the director's decisions in managing the corporation. The focus of this duty is the process by which decisions are made, rather than the substance of the decision or its eventual outcome. With that duty in mind, tell me, panel, how do you see the company's advisors assisting the directors in discharging this duty? And what's the process they should undertake?
Well, I guess I'll kick off.
This is Stacy Fox, and welcome to the audience. Thanks for joining us. I guess in terms of what advisors can do to help directors fulfill, as Judy said, it's really about process. And while the substance of a decision is not going to be double-checked, or double-guessed, I should say, certainly the process must be rigorous and complete. Everything from ensuring that there is sufficient data to back up decisions to appropriate and rigorous and complete minute-taking, as well as advice that has been well documented and the director's reliance on that advice in coming to a decision.
I might add that, one of the critical data points for me as a financial advisor is always trying to come up with those key information points, understanding what's key and critical to the board, and then understanding how much of that information is utilized by looking in the past, i.e. previous earnings, previous monthly or quarterly earnings, versus in the future, to trying to determine, is our strategy actually working? Are we progressing on the track that we're expecting to progress? And then how do I visualize that information back to the board? Is it better to visualize things through numbers on pages, or is it graphs, heat maps, those types of points? And as we put together presentations, when we start working with the board, one thing that we focus on is simply how do I actually disseminate the information and how often?
I will note that in the litigations that I've seen, this is Judy again, that emanate out of these restructurings, when the board gets sued for breaches of some of these duties, the key theme that I see is that either the board didn't act or didn't ask sufficient questions. So I think the process cannot be understated. I often have companies who the board will be meeting, but they're not keeping records and not calling it official board calls or board meetings, and they should, because inaction, I think, is often a cause that becomes actionable later on.
This is David DeRita. Thank you, everyone, for joining. The only thing I would add to that, and I would echo it, Judy, is I think there is a point in time, and we'll get to this a little later in the presentation, question, and it goes to most directors and most officers in major corporations understand how to go through a fulsome process of analysis once they've made the decision to do it. But I think the tricky part of the duty of care and the decision to create a record and the decision to evaluate the situation in the context of potential insolvency is that moment in time when a management team or a board decides they have to engage in that exercise in the first place. And I think one of the things we're going to talk about a little bit later is when should those bells be going off, because I think once the bells go off, we're talking about people who know typically how to analyze a question. And to your point, often the issue is, you never asked this question, you should have been asking it a year ago, you should have been asking it 2 years ago.
Exactly.
I think that, this is Chris from Morgan Stanley, and likewise, just want to have a welcome to everybody, but agree that that's one of the critical questions is, Tom, I'm sure you see this as well, one of the critical things for us as financial advisors is when are we brought in? Because clearly, I think one of our key roles in assisting directors is the diligence side, and I think that's where the question of when we're brought in is paramount, because that's when we can really dig in and help the company, help directors determine what situation they're in. And then I think our next role in helping directors is helping them evaluate alternatives. So I think diligence and evaluating alternatives are the role of financial advisors in helping directors.
The other duty that runs at play is the duty of loyalty. This requires that directors act in the best interest of the corporation, putting aside or subordinating their own personal interest to that of the corporation. It requires good faith, the good faith belief that actions are taken in the corporation's best interest. And this duty gets implicated where there's a conflict of interest. The one we see often is a corporate opportunity doctrine. A violation of that would be a breach of the duty of loyalty. Are there other examples that the panel may have of where directors can be really in a conflict situation where their duty of loyalty comes in?
Well, a couple of situations that I've been involved in personally have both involved close relationships with outside suppliers or customers where that relationship is somehow reflected in your board membership, that a particular board member will have a relationship with a key customer or key outside supplier. So as the directors are working through their decisions and the issues, you know, it's obviously critically important for any director who has those kinds of potential conflicts to be extremely cognizant of that, recuse themselves when necessary, and so forth.
The situations that come to mind for me as a financial advisor where this comes up the most often is in private equity owned companies where you have private equity directors or directors who are either directly affiliated or you know, have a variety of positions where they may be operating partners or seeking future deals with sponsors. That's one situation where I see this come up very often. The other is when you have a parent company who is involved in a subsidiary's distress situation. I had one client where we had a distressed subsidiary that was publicly traded, and its parent owned the majority of the equity, though there was still a small public float, and the parent was also the largest single creditor. So that created a lot of issues, and independence and creating an independent committee and creating a record was very important in that situation.
It's funny, I have often, this is Judy again, I have seen cases fall out of the fact where you have a multi-tiered structure, a board that is often the board on the various tiers in the family, and there are no actions taken for the subsidiary when the issues for the subsidiary are very separate from those of the parent. So I underscore what you're saying, Chris.
Well, the other situation that I think, particularly in a public company context, that sometimes is below the radar screen, but is, I think, always there beneath the surface, is the issue of executive management and directors, for that matter, financial interests in their equity position in the company. And as you're going through an analysis, whether it's a zone of insolvency or you get into troubled times, it's obviously very important. Sometimes that responsibility falls to the general counsel to make sure that decisions are being made, again, in the best interest of the company and not with regard in any sense to what the fallout may be for directors or management personally in terms of their equity positions in the company.
It's very important.
I think the one issue you run into, though, is when you have multiple companies, you have multiple interests. Directors may be directors of certain corporations and not others. So when you start, having intercompany accounts, people borrowing money back and forth, those are obviously problematic. And I guess you have to step back and, make sure that, number one, they're documented, and the rationale as to why we decided that was in the best use of both corporations, and in a certain case, is probably warranted. Also, whenever you're having self-dealings, i.e., maybe I have a personal guarantee on one of the bank loans. Should we pay the bank down? Do I not pay that down? Obviously, these types of issues are, in hindsight, are often scrutinized as to, why was that the prudent thing to do with the funds? So anytime you have related party transactions and you're nearing the zone or inside the zone, obviously there's just an extra amount of scrutiny that always takes place, and unfortunately it's after the fact.
Though it's important to note that probably the primary defense in this area is the business judgment rule, which is basically a presumption that the decision-making of the directors has been that they've acted on an informed basis, in good faith, and in the honest belief that the action that was taken was in the best interest of the company. This is a rebuttable presumption, but it's a very strong defense in this area. You can rebut it with evidence that fraud, illegality, lack of information, those kinds of things will rebut this presumption, but it's a very strong defense in the area. It's important to note, though, especially since we just had this conversation about the duty of loyalty, that it doesn't abrogate a director's separate duty of loyalty to the corporation. So you really have to take other protections if it's something that's going to create a conflict for the directors. Now, let's go to an insolvent corporation. When a company becomes insolvent, then that means the assets don't exceed the liabilities. Therefore, your equity is out of the money, and your real stakeholder is your creditors. So what happens to these duties? They expand. It's not that they're abrogated as to the shareholders, but they expand to include creditors as well as equity, because the creditors are the stakeholders that are the beneficiaries of the residual value, if there is any. So that begs the question, when is a company insolvent? And more importantly, case law has provided that this fiduciary duty to creditors, this expansion, occurs not only when the company is actually insolvent, but when it's in the zone of insolvency. So what are those factors? What are the things we should look at in addition to our traditional tests of insolvency? That is, the liabilities exceed the assets, or the company's illiquid, unable to pay its debts as they mature. Who decides? And what are the factors that we should all be looking at to see, is this corporation in the zone of insolvency?
Well, as we talked as a group over the last couple of days, there's obviously no bright line test to when you were in or when you were safe from the zone of insolvency. Our lives would be a lot easier if there were, but there are certain markers that seem evident or as a repeating pattern when you're talking about troubled companies that may be in the zone of insolvency. So, I asked my fellow panelists to repeat some of those we discussed.
From my perspective, a couple of things that I look at when I'm working with a company that may be in the zone of insolvency. I think first and foremost is liquidity. What's the company's liquidity? How much time do they have to evaluate options? That is critical, and that could be either impacting liquidity could be either immediate maturities, or something happening with the borrowing base, or something along those lines that it may be, or just simply a declining business that is impacting the company's ability to generate cash.
And let me interject there and say, if I had to say what is the reason that most companies file bankruptcy, it's illiquidity. Absolutely. So I can't underscore that one enough.
Absolutely. I think being focused on liquidity is absolutely critical, and that's something that Tom and I both focus on when we're advising clients. I think second, directors of companies are always acutely aware of what their stock price is. I think not just stock price, but understanding what the market is saying about all your securities, including debt, whether it's bank or bond. There are a lot of situations where companies may not have a public equity, so knowing where the debt is trading and why that debt is trading where it is important. It is a good marker of where you stand in the proverbial canary in a coal mine. Certainly, turnover of any kind of stakeholders is key, and Judy, you had mentioned certainly management turnover is something to watch out for. Likewise, turnover in other stakeholders, whether it's you have activist investors coming on, either as investors in equity or debt securities. I think that's a critical telltale sign. And then another key thing to focus on is supplier relationships, because that can really be critical to your cash. And when suppliers start putting you on notice, that's a very ominous sign.
I think some of the challenges for certainly people in industries like the auto industry is a lot of that is business as usual. And so particularly not so much liquidity crunches in the sense of violating covenants in loan documents, though everyone should remember those loan covenants were drafted by people who wanted to get an early warning well before insolvency. So if you're actually tripping loan covenants, it's a good indication that the kind of analysis we're talking about here ought to be underwent inside the organization, if nothing else. But you get it, in my background and Stacy's background, and I know yours, Judy, to a large extent, is the auto industry, where suppliers are always, in some sense or another, managing liquidity through their trade base. But there's a difference between kind of the ordinary course component of that and persistent distress. And if you look at companies, it's always great on the rearview mirror, but if you look at companies that went into Chapter 11, there's a fairly repeating pattern of watching them stretch out their suppliers, getting put on troubled supplier lists themselves by customers who are seeing that they're having trouble with, up and down their chain. Those are all indications of normal commercial distress, but normal in the sense of lots of industries are under pressure that create that, but not normal in the sense of something that you should be disregarding from the potential of being in the zone of insolvency.
I think one thing though, David, I can see companies moving from 45 days to 60 days, 70 days, et cetera, especially when it's seasonality, different parts of the year. And it's not unrealistic for the AP group to actually reach out to those suppliers and say, hey, by the way, for the following 3 months, we're going to be changing our terms. Obviously, when you start getting into COD and things like that, you've probably known that maybe something isn't quite right, and maybe I have changed, from, maybe moved certain zones, et cetera. And from a management perspective, I think it's always nice to have some type of a cash model that management's focused on looking at, so that you can always say, I've got some type of control in place so I can manage this process, and I'm able to manage the process. Number one, looking back historically, and also looking forward, though, for the next, what we refer to as a 13-week, kind of cash flow model, which is roughly a quarter.
Well, I mean, again, I think the issue is, and we talked about this a little bit prior to the session, there are certainly repeating and typical and cyclical issues that companies in various industries experience, but there's an element of, when you see it inside an organization, that this is unusual, that this is more than a one-time hit, it's more than getting over a hump that occurs every time this year. And that's why, to me, that's why directors and management get paid the big bucks. They have to have the courage and their own conviction to say, listen, we think we'll get through this one too, but this is different than the last time, or this is more protracted, it's a longer period problem. And so while we're working through it in the ordinary course and doing the things we know we need to do, we need to trigger an analysis that demonstrates that we are fulfilling our duty of loyalty and our duty of care, back around to the earlier points of demonstrating that you've exercised the business judgment rule. I mean, all of these things obviously overlap onto each other, and I think, as we were saying earlier, that's the hard part of this, is that the people who have to decide that they're outside the normal range of activity are the people who are closest to this and most accustomed to firefighting and most accustomed to getting over these things, which is why I think more often than not this does fall on the one member of the management team who is more detached from the day-to-day, and that's the general counsel. So it's a difficult problem, because it's essentially an analysis that members of the operational and finance portions of management feel they know best, and they're hearing from the pencil neck in the corner who says, hey guys, we might be in the zone of insolvency, we have to bring in financial advisors, and so there's a natural tension there, and so it's something that I think as professionals we have to be conscious of, particularly when we're executives inside these companies.
I think that's a great point, David, and we talked before about duty of loyalty and sponsors. I think that's a situation where I think often sponsors are some of the most valuable board members, because they know they're acutely financially aware. They know what the outside market is saying. They know that the company, that the investment community is starting to talk about the company as being in the zone of insolvency. Yet at the same time, they're also the ones who are probably the most conflicted by duty of loyalty.
Right.
So having a strong GC and having strong independent directors is critical there.
I mean, this is not an unusual thing. Those of us who recall in 2008 and 2009, 5 months before General Motors filed for bankruptcy, their CEO was saying that bankruptcy was not an option. Now, I know that they had actually analyzed the question, and so that might have been public relations, but it was actually poor public relations from the perspective of somebody who's trying to demonstrate that they're fulfilling their duty of care in a situation where it was utterly apparent that the company had tripped several triggers of potential insolvency. So it can be a very difficult thing to come to terms with. And there's a human element to it as well.
Yeah, I think directors need to realize that the CEOs might have some denial going on.
Yeah.
They need to bring to the table the asking of the questions when these factors come together. If there's a confluence of those, to be saying, am I in the zone of insolvency? And when you are even thinking you're in the zone, you should be behaving like you're in the zone. Because if you're thinking it, your safest course of action is to behave that way.
Well, and as we talked about over the last couple of days, that denial is one of the biggest challenges for professionals that are advising companies that may be on the brink of entering the zone of insolvency, because human nature and a good CEO even is going to want to believe that they can solve the problem. So in this case, directors really need to be vigilant about maintaining their independence with no disrespect to the management team, that the problems may be more persistent or may be signaling something more serious than what the CEO in his or her best efforts and in good faith want to believe.
Right, and that's where Tom and I think, have to play an important role and serve as arms and legs for strong directors, because it's challenging the management's business plan, challenging their cash flow forecast, because I think CEOs and management teams often, by definition, as you said, are optimistic, and that's how they've been successful in the past, but it's challenging those assumptions and the building blocks of the business plan, and saying, you know what, there is more of an issue here than meets the eye, and we need to really be on guard here.
I will note in closing this little bit of segment here that the duty of care is really one of maximizing the value. When you wait longer to realize that you're in the zone and get the help that you need, then you are limiting your choices, limiting your ability to maximize value for your stakeholders. So it is important, I think, to recognize that in this zone, your duty shifts. That said, though, let me give some solace to people on the phone in that the courts have cut back a little in this area on the ability to sue directors for breach of these duties. It used to be, previous cases, left the door open for direct claims by creditors against officers and directors of insolvent corporations. A change occurred in 2007 with the Gawala case, which really cut back and said that that creditors of an insolvent or a company that's in the zone of insolvency do not have a direct claim for breach of duty against the corporation. Rather, it's really a derivative claim. And just to go back over Delaware law, so everyone remembers a little bit about what is a derivative claim. That's a claim that requires that you be the stockholder, in this case the creditor, who is challenging the wrongdoing, that they have to remain that stockholder or creditor throughout the course of the litigation. But first and foremost, they must demand that the corporation bring the claim and must state why or has to state why that demand would be futile. And if the demand is made, then the failure to bring the claim must be unreasonable in order to allow the derivative standing. So that is a good thing for directors. It gives them a little solace. But where we really see these suits is that we see them go in nowadays. We don't see a lot of reorganizations, true reorganizations. We see sales, much like Chrysler and GM, with a liquidating plan that follows. These kinds of actions go from the corporation to a liquidating trust or a creditors committee to bring for the benefit of all creditors, and that's where we see them come. That's really the danger here. I do note that the Delaware courts have held that creditors can't bring derivative claims against the against LLCs because it's not in the LLC statute, so it's a little bit different. I want to touch on, before we move on deepening insolvency and talk a little bit about what that is. That became a rage when we saw all these bankruptcies occur, and basically was the concept of you've waited too long. As a result of waiting too long, the company's gotten even more insolvent than it was before. That deepening insolvency is an independent cause of action. Courts have cut back on deepening insolvency and said, really, it's not its own cause of action, it's a theory of damages. So we still see it, but it's more attendant to another cause of action. As a result, it's not a tort in and of itself. Now I'd really like to go to officer duties. First, we should all know that the Delaware courts have held that officers owe the same fiduciary duties as their directors. This was never explicit before, it's always been implicit, but it is now explicit in that case law. However, unfortunately, officers, unlike directors, can't rely on exculpation in the Delaware statute like directors can. We'll talk about that in a minute. So they really can't limit their liability in the same way. They have to instead rely on indemnifications and insurance. Let's talk for a minute about exculpation and indemnity, and then I'd like to open this up to the panel to talk about how these issues come up. I note that in the Delaware statute, it does allow, and many states follow the Delaware statute, it does allow for the provision in a corporate charter of eliminating or limiting personal liability of a director to the corporation or its stockholders for monetary damages for breach of duty. However, I note that does not include limitations for breach of the duty of loyalty. Again, that's sort of an animal unto itself. Also, it does not, it cannot absolve intentional misconduct or knowing violations of law. And similar to the breach of duty of loyalty, it can't be any kind of immunity from transactions where the director derived an improper personal benefit. So following this, many corporate charters do have exculpation. And even where they do or don't, we see in many bylaws indemnification provisions. And I've included in the materials a sample indemnification of officers and directors in corporate bylaws. How do we see, panel, this issue come up when we see insolvent corporations?
You know, Judy, I'm working on a couple of matters even recently that involve anytime an SEC investigation's going on. It seems like the officers and directors are brought into it through the SEC, so then they're asking for their indemnification, and the issues that we've run into is how do you actually get the funds from the company when the company is in the zone of insolvency, moving towards the illiquid state, etc., and who advances the funds first? Does the company advance the funds, or does the company notify the D&O carrier, and the D&O carrier advances the funds? And unfortunately, a lot of times, nobody really even knows how it works. And that's probably because nobody took the time to really understand the D&O policy when they went to sign up the D&O policy. I think the question people tend to ask is, well, how much is the policy versus how does the policy actually work? And then also in some of the certificates of incorporation, in particular in Delaware, they're writing in provisions now that state something about the corporation will advance the legal fees for D&Os if they're sued individually. And once again, those statements are great. However, the reality is many times the funds just aren't there to be able to stand behind the indemnities. So you end up with claims in a bankruptcy case, which may or may not get paid. You've got multiple entities, which entities are actually the claimants. So they're very problematic.
I would like to hear from the panel more about how this comes up, but let me just note, because you raised a good point, that the claim for indemnity is a pre-petition claim that is stayed by the bankruptcy. So I would go on to even say this. I'm constantly getting asked when I'm representing a board, not only do they ask me what the fiduciary duties are, but they always ask about this topic of indemnities, which I'll hear from more of you on. And then there's this issue about how does the money ever get advanced to them, especially if there's a retention on an insurance policy. And should they resign? So let's open up all these issues so we can hear from the panel on this.
Well, one thing I'll say about your last question of whether or not they should resign, what I found in my experience is directors first and foremost, and again, completely understandable, when you actually do file or get close to filing, that their primary concern is their own personal liability. And as a result, they tend to not want to resign, whether or not they see themselves as having a role or would prefer to get as far away from it as they can. They want to stay on the board to stay very close to these issues of indemnity, reimbursement for legal costs for any actions brought against them, and holding out hope perhaps for a release through the bankruptcy court at the end of the day, which of course is very difficult. So whether or not they should or would be any worse off stepping down, in my experience, is sort of a moot point because they typically don't want to for understandable reasons.
I would add this. When I'm asked the question, I note that in a bankruptcy scenario, everything out of the ordinary course of business has to come before a bankruptcy judge and is approved. So any extraordinary usual course of business action that would normally go to a board is going to be protected by the fact that parties have had notice and a court has made a determination that the action is in the best interest of the corporation. So you do not see lawsuits emanate from the period in bankruptcy. Right. They usually are generated from the activities or inactivities of the board prior to the bankruptcy.
Which of course is, puts the directors in the ironic position of having to be in the board when they can have the least influence over the company's direction, given that once it's in bankruptcy, it's truly in the thrall of a machinery that they can have, only a limited control over. So it can be very frustrating for a board member. And anybody who's a general counsel in a pre-bankrupt company, and I would say anybody on the phone who's a general counsel of a company that is not in bankruptcy is in a pre-bankrupt company, at least theoretically, should pay a lot of attention to the D&O policy and scenario play with a good securities litigator, whether that policy is going to hold up and deliver without question in a bankruptcy context. Not because there's anything special about bankruptcy vis-a-vis the D&O policy, but it's going to come under a great deal of strain because for the points that were raised before. Whereas in a non-bankrupt setting, you might get a claim. A company might decide to extend coverage or self-insure, if you will, for a period. Not going to have that option likely easily once you're in bankruptcy, and if the policy itself isn't ironclad, directors are going to be asking a lot of hard questions about that, and rightly so, because they have personal exposure. So D&O policies become critical in this environment, and I think it's more often than not the case that those policies don't get the kind of attention they deserve as to issues beyond how much do they cost, but is the insurance company required to advance, and are we going to be covered for claims that might arise in the context of bankruptcy?
And I think one thing that you sometimes lose sight about is, worked on both sides, either the defense side and actually the plaintiff side. But if you actually pursue the D&O policy and say the litigation is going to involve, many directors and officers, well, they have the right to go out and retain their own counsel. So before you know it, you may have 9 sets of attorneys and advisors and experts that, brought in, and, that policy just starts wasting away. So at the end of the day, there may not be a recovery. So, depending upon which side of the issue you're on, it's, you obviously have to think through the issues. How many directors and officers do I need, to bring suit? And then on the flip side, how many directors and officers are covered? And how do I spread out the coverage so that, outside directors still have money left versus, people inside the company, and the different types of coverages that, exist on the D&O side.
I have seen battles waged about the issue of whether the D&O policy is property of the estate or not. And because if it's property of the estate, then you can't even make a claim against the policy during the bankruptcy. So the important thing that I always do is when this issue comes up, and I agree with Stacy, I've seen this come up at the very outset of a company being in trouble. Directors are worried about their individual assets. Then you really need to have someone who really understands insurance look at the policy and let you know whether it is going to be available or not available to the directors if a suit occurs. So I always have my colleagues who are professionals in this area take a look at it. But Stacy made another point. Often the officers and directors ask the bankruptcy counsel, can I get releases? And that's a quagmire. In the bankruptcy arena, involuntary releases, I mean the ones that creditors don't agree to, are very difficult, if not impossible, to get. Numerous circuits, courts of appeals, have held that they're just not available, period, because they run afoul of the statute that says the only entity to get the discharge in bankruptcy is the debtor. Now that we see liquidating plans, there's even an exception to the discharge of the debtor if the plan is a liquidating plan, making it even hard for the debtor to get a discharge, let alone a third party like an officer and director. In those cases in which releases have been allowed, courts have required not only evidence, but evidence of a substantial contribution made by the officers and directors. That circles back to, if you're a former officer and director, there's not a way in the world that you can be making a substantial contribution without some monetary or some other contribution. Other courts have looked at whether the remaining, the fact that you've remained as a director and discharged your duty is a substantial contribution. And you can imagine that courts have said, doing what you're supposed to do really isn't a contribution. That doesn't work. So while this is on the minds of the officers and directors, from the outset, it really is a problem that isn't easily fixed.
Yep.
I don't know if others of you have experienced this.
It's just, it's something that certainly hangs over every case, I imagine. I've certainly hung over the case I was involved in, and ultimately was resolved positively. But it's, there's not an easy answer to this one. I guess the answer is try to avoid getting into bankruptcy. No offense to your practice.
And make sure, to the central point here, make sure your D&O policy, you understand it, and that not just the amount is sufficient,
Yeah.
but the terms of the policy are advantageous for your directors and officers.
I really think in the end, the rest of the things we're talking about are imponderables. This is something that a general counsel and a CFO and a CEO can make sure of. They can do it.
Yeah.
It might cost more money to get the right coverage, but you can get the coverage you need and you can protect, the D's and O's here, and that's what the insurance is for. So.
I guess it kind of goes back to, what we reiterated earlier, that there's nothing wrong with bringing in an outside advisor to assist you with certain issues. And, D&O coverage is obviously one of them. Maybe the CFO isn't the best person to advise you on, the rights of the carrier, what the carrier's history is in the marketplace and those types of issues. Just as maybe an advisor's, better suited to come in and help you validate a business plan. To me, the issues are very, very similar. Very rarely are you going to get criticized as a director or an officer to bringing in outside help. The criticism tends to be, from being internal and continuing to make the same, issues or mistakes as people would refer to, or lack of control, versus saying, hey, I brought in some outside advisors to help me with these issues. So understanding how the coverage works, benchmarking is a great way, looking at companies in your industry, companies similar size, what are they doing? Typically these external experts will have all of those types of data points for you to evaluate, your coverage. And obviously you want to know the issues before somebody wants to ask you for your D&O policy. You'd like to know how it works, especially if you have international operations. If I have issues overseas, are they covered by my policy? Are they not covered by my policy? What happens? Does it matter? And unfortunately, a lot of times these questions are asked after the fact versus before you need it.
One of the, certainly in my personal experience, I've been very blessed to work with some very good risk management directors at companies, and this is insurance. It tends to fall into the risk management purview, though they certainly recognize that this is a particular policy that's maybe more near and dear to the hearts of the directors than the general liability policy on their leased space or things like that. And so, but in my experience, risk managers increasingly are sophisticated about this, and they're asking those questions of their own advisors, their insurance advisors, and pulling the general counsel in because they don't want to make the decision in a vacuum. If you're a general counsel and your risk manager isn't engaging with you, particularly on the D&O policy, it's a good indication that you ought to get proactive.
Well, I'd like to give some key takeaways from my perspective and ask my panelists if they would have anything to add. If I had to give some key takeaways, it would be number one, that the suits that I've seen come from the pre-bankruptcy period when you're in the zone of insolvency. So as counseling officers and directors in that role, make sure they're asking the right questions, that they're not missing the warning signs that often are indicators that the company is in trouble. When you're on your fourth or forbearance agreement, or even your first forbearance agreement for that matter, or your 16th amendment to the credit agreement because you're blowing covenants, a bell should be going off in your head, and the other things that we indicated. So that's the critical area. I see more of the lawsuits about inaction than I do about action. It's not so much bad decisions, because again the business judgment rule is so broad and encompassing. It's about the failure to act. So make sure the board is acting, that they're diligent in getting information, that you're recording the fact that they're acting and inquiring, and most importantly, relying on professionals to the extent necessary. Those would be my key takeaways. Anyone else in the panel, was there something you would add to that?
Yeah, Judy, this is Tom Bibby. I guess to me, the focus is, I like to be able to say I've relied on external experts for different areas. And if I'm thinking if I don't know if I'm in the zone of insolvency, but I'm thinking, gee, maybe I am, obviously I think that's the right time. And it can be as simple as, my CFO's given me great presentations, great knowledge, great, rear view mirror, hindsight, etc. But is it worth spending a little extra money and having somebody from the outside come in and try to validate these points? Maybe even benchmarking against what are my competitors doing, or is everybody in the oil and gas industry suffering today? Is it just us? I mean, how does this, fit within the overall, architect of where we reside? So I guess I would say, ask for help, ask for assistance, and there's probably not a better defense than to be able to say, hey, you know what, we thought of that, and by the way, here's what I did. I brought in the following experts in these areas to sit with our board and to help us through these times. So that would be kind of one area that I think is, pretty important from a financial standpoint.
Well, and this is something that we talk about in the context of board activity in general. But as directors, don't feel it's a sign of disrespect or somehow a lack of faith in the management team to ask the tough questions. You're actually doing the management a favor by doing so, and that can't be impressed upon I think the audience enough. And also, if you're on the management side, don't take it as a lack of respect or a lack of faith when your directors are asking really tough questions or asking for support from outside advisors. They're doing their job.
Other key takeaways?
No, I think this is David. I agree with all that. I think it's, again, for those on the phone who are in the position of chief legal officer of a company, it's important to keep in mind that better or worse, this analysis resides in your shop with the CFO, unquestionably, but that and in that sense, not a bad thing, I guess, to spend a little time in a quieter moment with key members of management saying, hey guys, I've got an idea, we're going to talk about this, even though it has no applicability to our company, of course, but it has a lot of applicability to a lot of other companies, so that we can all agree amongst ourselves what our action plan and how we would mobilize to protect ourselves and our directors if any of these things occurred, even though we know it's not ever going to lead to Chapter 11 for our company, because it's just sound business practice. It's just a risk management strategy is what it is.
Yeah, I think my key takeaway from this is, to David and Stacy's point, is a lot of this does, in deference to your audience, that does have to be led by either a general counsel or a strong independent director, because I believe, certainly on the diligence side, that financial advisors often aren't brought in until they're requested by a GC or by a management team. I think Tom and I calling on somebody saying, you guys aren't looking so good isn't the best calling card to bring to the table. So I think this is really incumbent on your audience to drive the process.
Well, I want to thank the audience for their participation and turn it over to Jennifer.
Thanks, Judy. Before we get into the Q&A portion of the program, I do want to make a brief CLE announcement. Those seeking Kansas, New Jersey, or New York CLE credit are required to use the following 4-digit code to complete the attorney affirmation form. The code is 4VSR. That's the number 4, V as in Victor, S as in Sam, R as in Richard. To obtain a copy of the attorney affirmation form, download it from the files box at the right side of your screen, or you can email me, Jennifer Bartz, at jbartz@foley.com. Once again, the code for the attorney affirmation form is 4VSR. That's the number 4, V as in Victor, S as in Sam, R as in Richard. This code is only needed for those requesting CLE in Kansas, New Jersey, or New York. At this time, this concludes the CLE announcement. And let's head over to the Q&A portion. We do have 2 questions in the queue. Judy, do you want me to read these off, or are you able to see them?
We are not able to see them.
Okay, so the first question says, can you please comment about the presence or absence of business judgment as defense at the motion stage of litigation, and also to what degree is it being undercut by negligence or abdication of care arguments?
Good question. Business judgment is a presumption. It has to be rebutted by evidence, And if there is some factual issues that can be raised, recall at a motion to dismiss stage that you have to take what's alleged in the pleadings is true against the non-movement. So, if there are facts that are alleged, it's going to get you into discovery, and you could not be able to get out on the motion to dismiss.
Thank
Your
you,
next
Judy.
question? I know we're a little bit over time, so I'll move quickly to the next question.
Yep. One last question. Are there also issues to consider in terms of how claim is defined under policy to make it comprehensive? For example, covering expenses incurred regarding investigations or audits, etc.
Anyone on the panel able? I don't feel knowledgeable enough about the insurance law to answer that one. So I'm not sure I can take that. Anyone else? Nope, we're going to have to decline that one. That's really
Okay.
more a question of insurance law.
All right, well, that concludes the Q&A portion then.
Thank you, Jennifer. Thank you, audience.
So thanks, panelists, for your excellent insights regarding the director duties in the zone of insolvency. The contact information for everybody is on the slide deck if you would like to reach out to one or more of the panelists. The PowerPoint and recording will be available on our NDI website by next week, early next week. Please mark your calendar for the final session of our 2013 NDI Checkpoint Web Conference Series on December 4th. And don't forget, those seeking Kansas, New York, and/or New Jersey CLE credit are required to complete the attorney affirmation form. Email the code to jbarts@foley.com with your completed form. And we hope you enjoyed today's presentation and ask you to take 30 seconds to participate in our brief online survey at the conclusion of this call. These surveys are very helpful to us in ensuring that our NDI programs are providing you with practical advice and recommendations and developing ideas for future NDI topics. Thank you again for attending our NDI, and we'll talk to you next on December 4th, 2013. Program details will be announced later this fall.
That does conclude today's conference. Thank you for your participation.